Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're talking about the SEC's new marketing rule, and we're joined by an expert on the topic. Ira Kustin is a partner at the law firm Paul Hastings. Ira, welcome back to Talks on Law.
Thanks, Joel. It's great to see you.
Well, let's talk about the marketing rule. I guess first off, what is the rule and who's covered?
Sure. So the new marketing rule is a rule under the Investment Advisors Act of 1940, and it applies to investment advisors that are either registered under the Advisors Act or required to be registered under the Advisors Act, even if they aren't.
Maybe we should put a caveat since we're lawyers. This won't be the be-all, end-all, but we'll give some insights and some high-level coverage of what's new.
Yeah, that's a good point. The marketing rule is complicated. And so you're right. This is just a very brief overview.
The rule itself is called the Modernizing Marketing Rule for Investment Advisors. I guess first off, why? What was the reason for the SEC implementing this?
That's a good question. What's the point of all of this? So under the Advisors Act, before there was a pre-existing advertising rule, but the pre-existing rule was fairly basic. And to be able to operate in compliance with the rule, advisors also had to navigate this web of no-action letters that the SEC put out over a period of decades, which, oftentimes those no-action letters would seem to contradict one another, depending on the topic. Some were clearer than others. And so the SEC's intent was to replace all of those no-action letters with one clear, comprehensive rule that covered not only advisor marketing, but also solicitations and placement agent activity.
So the old rule was then modified by this multitude of no-action letters, or I guess you could consider it addendums from the SEC. That sounds like it's only good for someone like yourself, Ira, who can take the time and go through the weeds and then advise their clients.
That's a good point. So yeah, it works for lawyers who understand those no-action letters. But the tricky part is that no-action letters technically only apply to the recipient of the letter. And so what grew up over time was industry practice that related to those no-action letters and more or less relied on them, even though as a technical matter, they only applied to the fund or the advisor that was the recipient of the letter.
Rather than going through this large document, line by line, why don't we take an overview of what's important? What are the key changes that investment advisors should be caring about?
Yeah, so I think the easiest place to start is with the definition of advertisement itself, because you want to determine whether or not the materials that you're sending to potential investors or existing investors fall within the scope of the rule.
Yeah, so what did you find was interesting in the way they defined advertisement?
Yeah, and here I'm literally just going to, read from parts of the rule because this is something that is fairly technical, but there are two prongs to it. First, an advertisement is any direct or indirect communication that an investment advisor makes that offers the investment advisor's services with regard to securities to prospective clients or private fund investors, or offers new investment advisory services to current clients or private fund investors. There are some exclusions for one-on-one communications or communications that are specifically requested by an investor, which is helpful in practice. The other prong that sort of folds in what used to be a separate rule under the Advisors Act is any endorsement or testimonial for which the advisor provides cash compensation or non-cash compensation.
Yeah, this was interesting. So if you're getting a testimonial and you're paying that person, it applies. The rule applies.
Correct. What the SEC did was essentially fold in the old solicitation rule into the new marketing rule.
Why don't we talk about some exemptions or exceptions that were set up in the new rule. What jumped out at you?
So just running through the exemptions that are in the rule itself, extemporaneous or live communications one-on-one with a potential investor or current investor are excluded from the definition of an advertisement. Information that's included in any kind of a regulatory filing, something that appears in your Form ADV, or something else that's required to be publicly disclosed, also is not an advertisement. The SEC's rationale being you have no control over that. And then finally, communications that include hypothetical performance are not within the rule if they're specifically requested by an investor in a private fund, for example. So if an investor is thinking about investing in your fund and as part of their due diligence, they ask you to provide specific examples of performance that may not be actual performance, that's permissible. Although, there are certain guidelines that we normally recommend when you're providing that information to that party.
What do you mean specific examples of performance that may not be performance?
There's a difference between actual performance and hypothetical performance.
Okay.
Hypothetical performance could be if an investor wants to know what performance would look like if you removed a certain subset of investments from one of your prior funds. Those types of performance presentations can be permissible if an investor or potential investor specifically requests it. Although we recommend that it be presented in a certain way so that it's clear that it falls outside of the marketing rule.
One of the things that I thought was interesting in reading about it was if you use certain charts regularly in your advertising materials or in client pitches, that chart in and of itself can be treated as advertising under the rule.
Oh, absolutely, absolutely. So, one of the trickiest parts of the rule is how you present your prior performance. And we'll get into a bunch of detailed definitions of different types of performance that you can present and the requirements there. But that is actually one of the more challenging parts of the marketing rule.
What about general prohibitions? What was there anything in the rule under things that are just outright banned that jumped out at you?
Yeah, absolutely. And some of these, seem obvious on their face. And I'll just quickly run through that list of overarching general prohibitions. So the first is making an untrue statement a material fact or omitting a material fact necessary to make the statement made in the advertisement in light of the circumstances under which it was made not misleading. So, for any securities lawyer, this language is going to sound familiar and is not surprising at all. The next is making a material statement of fact that the advisor does not have a reasonable basis for believing it will be able to substantiate upon demand by the SEC. What that means as a practical matter is you need to have backup for any factual statement that you put in any marketing material. So in a PPM, in a marketing deck, if you include some statement of fact, you need to have backup for it.
So in a hypothetical world, if something I know to be true, I know that it's true, but I have no evidence, perhaps that evidence vanished or was eaten by my dog or whatever, I can't include it.
There would be some risk if you don't have backup in your files.
Sorry, I interrupted. If you want to jump back into the list.
So just quickly, continuing to run down that list. And again, this is a broad overview, so we're not covering all the details. Discussing any potential benefits to investing in your fund or account without providing some fair and balanced treatment of the related risks, part of the general prohibitions. So referring to specific investment advice that was provided by the advisor in a manner that's not fair and balanced is also prohibited. And so this really is addressing the SEC's concern about cherry picking. So, for example, if you're including case studies in your marketing materials, you're going to want to make sure that they're being presented in a manner that's fair and balanced. And there's also a sort of general overall catch-all that puts a prohibition on including information that is otherwise materially misleading. So that's sort of a broad catch-all that the SEC can point to.
It wouldn't be an SEC rule if it didn't have a catch-all.
That's a good point.
Let's talk about performance, Ira. What does the new rule require that's of note?
On the topic of presenting performance in marketing materials, there's a number of subtopics that we should just quickly cover. But
Please.
I should note for anyone who's watching this that each of these topics is something that you need to study in detail. And so, again, this is a very broad overview. The first is what we call related performance. And so, if you are showing the performance of more than one portfolio, and the SEC considers a portfolio to be a fund or an account that the advisor advises. Related performance shows the performance of more than one portfolio that may have similar investment strategies, similar policies. You want to make sure that that's presented in the right way.
That was related performance. What does it have to say about extracted performance?
That's when you may be showing a subset of investments that fall within one portfolio. In that instance, again, there are other requirements, but you're going to want to either show the performance of the entire portfolio along with that extracted performance, or at least offer to provide it.
How about hypothetical performance, Ira?
Hypothetical performance, as its name implies, is anything that is not actual performance. So if an investor in the fund or the fund itself didn't actually realize the performance that you're showing, there, again, are a number of requirements, but the basic idea there is that you need to show all of the assumptions that underlie those hypotheticals. And that could be in footnotes on the actual page where that performance is shown. It could be shown in more detailed endnotes. But there are a number of different types of presentations that are going to fall under that definition of hypothetical performance.
And what about predecessor performance under the new rule?
This comes into play when an advisor is showing the performance of another advisor. Say, for example, a group of three people go off and start their own advisor and want to be able to show the performance that they were responsible for when they were with another advisor. So there's a right way and a wrong way to do that. But again, the sort of underlying theme there is that the SEC wants to ensure that there's some continuity of the people who are responsible for the performance at the earlier advisor and at the advisor that's using that performance in its marketing materials now.
So if hypothetically you and I and Janet Yellen ran a very successful private equity fund, and then you and I split off, we might be able to use that prior successful track record, but we'd have to say, we didn't have Janet Yellen, and we don't have her anymore. So, keep that in mind.
Yeah, well, based on those facts, that may be a tricky scenario, but yeah, so in certain circumstances, you would be able to use the performance of an earlier predecessor advisor, but it's not permissible in every situation.
Ira, what about the new rule and how it treats gross performance versus net performance?
Before the marketing rule came into effect in November 2022, there was pre-existing guidance from the SEC that in a number of circumstances, if you were showing the gross performance of a fund or account, the SEC also wanted to see net performance shown with equal prominence. So that means on the same page, the same font size. And the difference between gross and net is that gross performance shows the performance of the account before you deduct the impact of fees and expenses. So net performance is going to show what an investor or what the fund would experience after you've deducted the impact of management fees, carried interest or other performance compensation, and actual just day-to-day expenses. And depending on the strategy of the fund and how it's performed, there could be a significant difference between gross and net. And so the SEC considers it misleading for you to show just gross numbers without the net equivalent. So one tricky aspect of that the industry is still struggling with is that the SEC announced in an FAQ, and not actually in the rule itself, but just an FAQ that the SEC posted on its website, that when you show even the performance of just one individual investment within a fund, they expect you to show the gross performance and the net performance. And historically, the industry has taken the approach that for individual investments, it in certain circumstances is difficult or nearly impossible to figure out what the net number is.
Might be tricky to say, what amount are we taking out of that particular transaction if we're also running, four others simultaneously.
Right, exactly. So, certain fund expenses are fund level expenses, not investment level expenses. Management fees apply at the fund level, not investment by investment. And so, the industry is struggling with that at the moment. But the general approach that people seem to be taking now is to come up with some methodology, and in some respects it's an artificial methodology, but some methodology for showing a net number and then including a footnote or some other disclosure that describes the methodology in detail.
So, Ira, we've been talking mostly as if the marketing is being done by the firm itself. What if there's an intermediary or some type of placement agent or contractor that you're using to do your marketing?
Yeah, the use of placement agents or other parties that you may pay to solicit investors is, very common in our industry. And under the Advisors Act, there used to be a separate rule that covered that activity. It's now been folded into the marketing rule. And there are three basic requirements to keep in mind. And again, this is a very broad overview, but the requirements are that you disclose whether or not whoever is giving that testimonial or paid endorsement, whether or not they're an existing client or investor in your fund. You actually need to have in place a written agreement and have some assurance that whoever you're paying for this activity is complying with the marketing rule themselves. And then there is a set of disqualification rules. And so there are certain parties that you actually cannot pay for endorsements or testimonials. And those disqualification rules, of course, also have exceptions or exemptions, which are, complicated enough that we could talk about those just on their own for an entire hour or so.
Ira, the SEC gave a grace period where advisors could be using the old rule or the new rule. They just had to pick. That grace period is over. Am I right? The new rule is fully in effect.
Joel, that's right. Compliance with the new rule was required as of November 4th, 2022. And there was a period of time before that compliance deadline where you could either choose to opt into the new rules or abide by the old rules, but you couldn't do a mixture of both. Now, after November 4th, you have to fully comply with the new rules, and there's no mixing the two.
So, Ira, before we let you go, again, this is just an overview. So, for those watching who are in the space, don't give yourself a green check and go for it as if you've now understood every nuance.
Yes, this is a broad overview, but as far as next steps are concerned, any registered advisor is going to first want to look at their existing marketing materials and make sure that they're compliant with the rules. And so, in most circumstances, for most advisors, that's going to require you to update your existing documents. Next, obviously, when you're producing new materials, you're going to want to make sure that to the extent that you're recycling performance data or other materials from earlier funds, you're going to want to make sure that that's presented in a way that's compliant. To the extent that advisors have not done this already, they're going to want to revisit their arrangements with any of their placement agents or similar parties to make sure that any placement agent agreements or other arrangements that they have in place also comply. And then advisors finally are going to want to update their policies and procedures internally to make sure that they're current with the current rule and don't just address the old rule that used to be in place.
Ira Kustin is a partner at the law firm Paul Hastings. Ira, it is always a pleasure. Thanks for joining us today.
Thanks, Joel. Great to see you.